good, and thank you, Linda. I'm a senior partner with Miller Canfield. I run our corporate practice in Ann Arbor, and I run our New York office. So today, it sounds like you've already had, those of you who have attended, or those of you who may attend in May or August, will get some input on Regulation D, Regulation A+, Rule 144, and the various state equivalents of those, all of which are requisites for actually selling the security. The thing that people often forget, and kind of why I'm here today, I get the easy part instead of going through anything technical. My presence and speech here today is to kind of give you some of the things that if you do these things correctly, it helps you raise money when it comes time to go out and do your Reg D offering or do your 144 or your A+, different things. Whereas if you do them wrong, it will jump up pretty quickly in due diligence. And for those of you not familiar with the term, that's essentially when you go to start raising money, and maybe let's use, for example, that you're talking to a venture capital fund. One of the things they're going to do after they've discussed kind of the financials and looked through that on their internal is send out basically a guy like me and tear through every piece of paper from the day your company was formed. And so we're going to go through some of the basic things, most of which hopefully will illustrate with examples today should be self-evident, but it is a consistent theme that when I'm on the representation of either a private equity fund, a venture capital fund, or even a private entity going to buy smaller startup, pre-income, just income phase, can be very difficult, and you unearth a lot of things. So we will go to our first slide here. So premise you're going to start seeing quite a bit. First slide here is you will see that the Internet is not a substitute for proper advice. The Internet now has tons of documents out there, and if you're good with Google, you can find just about any document you might like. Later on today, we're going to talk about founders agreements. If you go on Google, you're going to find a bunch of them. The key here, though, is every entity that you create is different, okay? Just because you found a good form on Google, you don't know if someone who was a lawyer wrote it. You don't know if it's a lawyer who does startup work or does investment work, so that you're getting a document that fits what your company is not only planning on doing, but is currently doing as far as setup. Kind of the danger, you'll see that on the specific. So the example that I use here is one of the forms, very easy to form your company, at least the beginning of it, is to go on to the LARA site and get a set of they have a form of articles of incorporation. And I've had an awful lot of people walk into my office who have that form that they've downloaded from LARA, and they sign it and they send it in. And I think the filing fee is about $60, and they think they have a company. Well, you have part of a company, but you don't actually have a fully formed actual company because you're missing a number of documents, and we can get to that in a minute. More importantly, there are several provisions that Michigan's corporate law allows you to put into those articles. For example, exculpation for officers and directors. So unless they breach their duty of loyalty, they can't be held liable for monetary damages. Very important provision. Very useful to have, but not in the baseline form from the state, because it goes beyond what the state is basically willing to do, because it involves legal advice on the adaptability and viability of that to the individual business. Another example is, in certain circumstances, you're allowed to have a provision which deals with community of creditors in the event of dissolution and how those will be treated. Also not in the form. So while you will have a set of articles on file, they may not be what you need, and they may not provide to the full extent allowable under Michigan law the benefits to which you should try and avail yourself if you can. So then that brings to the next piece, which you'll see, which I've called self-adaptation is not an option. The other thing I see is people didn't go on the web as much as they've got a friend or someone they met at a seminar or just someone they met somehow, and that person had the documentation for forming their company. And so they changed the names. It looked big. It was long, kind of moderately illegible and unintelligible the way lawyers write. So that seemed like a good form. And it worked great for their friend. So the problem is that may not work real well, again, for your business, notwithstanding that it was a perfectly valid document for that person. So the example you'll see I have where you see on your screen EX, Michigan IP assignment form. This was a client that came in, had operations in Michigan and were California. So they had an intellectual property assignment. We'll get into what those do in a few minutes, but suffice it to say it's something that is very useful. And it was a fantastic document, incredibly well written, very, very good document for use in the state of Michigan. So they, as they went into California operations, they merely changed the location and location of the business for the office it was at, and had all the California employees sign that and just went along writing software code. The problem with that is, while the document was incredibly well written for Michigan, California has the most strict, restrictive, and stringent, not sure how many more adjectives I can use there, limitations on the use of intellectual property assignments for employees of anywhere in the country. They have a very specific law on what could be done. Certain provisions have to be included to make it of any use. And most people who are familiar with it actually include a copy of the statute so everybody's on exactly the right page as part of the document. So while these people had a very good form, this client, and it was completely useless, and they had had several employees over several years writing code under a document that was essentially completely void in the state of California. And now you're kind of thinking, okay, well, what does that really mean? What that means in practice is if you invent something, intellectual property specifically, those are the property rights, ownership rights of those things are down to the inventor. So the person who wrote the code owns the code, absent an agreement that says otherwise, or absent an assignment by which that person assigned it to the company they work for. So while this company was merely going along, and they had written about 80% of their code at that point, they had no protection whatsoever and didn't actually own it. Okay? So that's kind of one example of a great legal document just doesn't do what you need it to do in your circumstance. So we go back again to a good lawyer and a good accountant. The accountants become incredibly important because getting your books and records set up at the beginning, getting the tax advice set up in consultation with your lawyers at the beginning is incredibly important to make sure that you're starting out on the right footing. There are a lot of very good accountants out there, but they don't do a whole lot of early stage company work, in which case they may or may not be familiar with some of the things that an early stage company can do, or tax treatments they may be able to take advantage of, or to assist in the structuring, how the company is structured from the beginning, be it as an S corporation, an LLC, a regular corporation. And each of those have tax implications and ramifications. And so you'd like to have that done with your lawyer in consultation with your accountant. Okay? So if we go now, next thing you'll see is this is kind of key off what we were just talking about, right? Failing to plan, planning to fail. And this goes back, if you remember a moment ago, we touched on the concept of you've now downloaded your articles, notwithstanding what we've just talked about, or you did it last year, and you filed them with the state, and you think you have a corporation. The challenge there is you don't actually have a corporation. You have a filing. And the reason for that is there are certain documents that are required. A corporation in the state of Michigan, for example, must have a board of directors. It must have bylaws. It must have a president, a secretary, and a treasurer. Now, those rules, as far as the three officers I just named, vary by state. But the underlying premise that you have to have a board and that you have to have bylaws is pretty much universal. And you also need to issue initial stock. And this is one where a lot of the startup entities get themselves in trouble. You have, especially sometimes with only two owners, they didn't actually have the board of directors have a meeting, authorize the issuance of the stock, set the price of that stock at which it will be sold, and issue stock certificates. While stock certificates are not absolutely required, at the early stage they do help you keep track of and confirm that you've actually issued stock. And I realize there's at least probably 50% of the audience that's listening to this is going, well, of course that happens. I can tell you I've had two companies that my client was looking to buy in the last year that we went in and one of them had purportedly 7 owners and not a single record of a single share of stock being sold to anyone. Now, you might initially think, well, that's easy because there's just 7 guys and we had agreed a long time ago and we'll just issue it. The challenge with that becomes if you issue the stock at the beginning on the agreement of the parties, however that's going to be, and for the consideration agreed to by the parties, then you have shares, those are issued, and you know what they are. 3 years later, it is virtually inevitable that at least one of those 7 people will say, well, hold it, I actually did more than so-and-so did, and he was supposed to do this other stuff and didn't, so I should actually get more shares. So now you've got at least 2 problems. One, you have a dispute over the ownership, and you've been operating for a while, which also means you've been filing your tax returns based on the ownership you've talked about. Can it be fixed? Yes, most of the time. Virtually everything we're going to talk about can be fixed today. The challenge is, if you haven't done it at the beginning as we're discussing, what you're going to end up with is a position where when you go out to raise funds, and you go to we'll keep using a VC fund here in town, so we'll say you go to talk to, RPM Ventures. They're going to find these things. And now at the point where you're actually looking to get money, so you're already kind of a little bit at a disadvantage, right? You're the one asking for money. They're finding more and more things wrong. And human nature, as you might expect, the more I find wrong, the more I assume to be wrong. And those things cost money to fix. So you kind of don't have it. That's why you're looking for it, but it costs money to fix it so you can get the money. Now, sometimes will a fund that as part of it, part of their investment to get it cleaned up? Yes, but they're not doing that for free. So that's an additional cost. If you thought you were going out for $1 million and they have to put in $25,000 to fix it up, well, that $25,000 is now going to be either on a note with a pretty good size interest rate, or it's additional equity that when you were doing your computations on what you wanted to sell, you didn't think through. Okay. Next thing, we've touched on the board of directors. Let's talk back. You heard me a minute ago talk about C Corp, S Corp, LLC, world's fastest primer. A C Corp is the traditional corporation that we're all used to thinking about. Okay. Easiest example, Ford Motor Company. It's treated as a corporation for both state and federal tax purposes. The entity has income, pays expenses. At the end of the year, it has profits, and it pays taxes on those profits. To the extent it has money left and decides to make a distribution, it distributes those funds to its shareholders, and those shareholders pay taxes on those distributions as ordinary income. The other side of that is what's called an S corporation. It's a special type of corporation, so it is a corporation for state law purposes, but is treated differently, is treated as a partnership for tax code purposes. So we just walked through how the C Corp, so in the S Corp, the company makes money, pays expenses, at the end of the year has profits. The company itself does not file a tax return. Those profits, excess funds, are, whether they're distributed or not, are deemed to be allocable income to the holders, the owners, and they pay tax directly on their 1040 for that allocable income. It can be very advantageous, but there is a limitation in that S corporations, because they're exclusively a creation of the tax code, have certain limitations. You can't have more than 75 shareholders. You can only have certain types of shareholders, U.S. citizens, certain very specific types of trusts. So you can't always just say, I'm going to be an S Corp. Additionally, should you, after consultation with your lawyers and accountants, decide you would like to be one, there is a very specific form that has to be filed with the IRS, has to be filed within 75 days to get your S-Corp status. There are some exceptions, and you can make an S-Corp election later, but generally you want to get that in within 75 days, or else now you got to go forward. That leads naturally to the question of, can I change? I started as a C Corp, I want to be an S. I started as an S, can I go to a C? The answer is yes, but you need to be aware that there may be tax consequences to that change, especially if you're going after changing from one to the other after a period of operation, because the IRS, as you might expect, always wants to try and get their tax money. And so sometimes you can have tax recapture issues, well beyond kind of what we're talking about today, but just bear in mind that that initial decision is important. The other type of entity you see, which is the one often you'll hear about, is an LLC. An LLC is not a corporation for state law purposes. It is what's called a limited liability company, has its own state law provisions, and it is treated as a partnership for tax purposes, much like the S-Corp we just talked about, with one significant difference. It does not have limitations on who the shareholders can be. So we just talked about 75 and U.S. citizens and certain types. None of that applies to an LLC. Okay. One of the other things now, you'll see something on founders agreements. This tends to always be somewhat difficult, so we're actually going to spend a couple of minutes on this one. Well, let's assume we have 4 people. They decide they want to form a company together, and they're going to write software. Okay, so they form the company ABC Co. They get their board of directors, which is all 4 of them. They do all the things we've talked about. So the initial shareholders appoint a board, the initial board appoints the officers, stock certificates are issued, everything else. Okay? The difference is here, and one of the things you want to make sure you're aware of is, as the founders, especially at the early stage, it is often the case where sometimes someone either doesn't do what the other 3 thought he would do, decides not to participate anymore, or participates less than everyone projected when you set out the giant sheet that said, you know, Bill's going to do this, Ann's going to do this, Jan's going to do this, and Tom's going to do this. So the question becomes, okay, how do you deal with those situations? And how you deal with those is what's called a founders agreement. This starts setting 2 basic rights, interrelated, one of which is the right of the company to buy back the stock on certain events. And as you might think, right, people don't just sell the stock back because. So this contract ties up the rights for how that would work. And the reason you do that is you set up the triggers. And they're normally done in accordance to what's called, you'll see the reference on the screen, to reverse vesting. Reverse vesting, if you think about your stock options, everyone's heard about stock options, right? So a stock option works where I've granted you the right to buy 10 shares over the next 3-year period, and your right to actually buy those shares vests over 5 years. So at the end of year 1, you can actually really only buy 2. At the end of year 2, you can buy 2 more, on and on until you've bought them all, or bought none later, however you want to do it. The concept in the founders agreement of reverse vesting flips that on its head. So if you remember where we just started, the shares have all been issued to each of the shareholders. They own them. So what you're setting up is a mechanism by which the corporation has the right, or the shareholders, other shareholders, have the right to buy those shares back at a specific set negotiated price, which is often different depending on what the trigger is, from a shareholder. So the shareholder is required to sell those back if these things happen. And rather than the vesting where you think it gives you the right, this has the right fall away. So if we've issued 10 shares to Tom, at the end of year 1, and we set a 5-year reverse vest, at the first year of operation, the company has the right, upon these triggers, to buy all 10 shares back from Tom. At the end of the first anniversary, the right to buy falls away with respect to 20%, so now they can only buy back 8, so on and so on. Why that becomes important is if you tie it in, and I'll use another example, I had a client, they had done everything right up to it, but they did not get kind of a founders agreement in. And about 2 years or a year into the operation, one of the key founders just disappeared. actually moved to Belize. Couldn't find him. Took a lot of work to even find out that he was in Belize. Well, the company was being sold, and the purchaser insisted upon an acquisition of 100% of the shares, as you might expect, right? I want to buy the company. I want all of it. Well, that put the remaining 3 shareholders in a pretty difficult spot because they didn't control 100% of the shares. They controlled 75. And the person who was in Belize, at least as they believed at that point, couldn't be reached, couldn't be found to sell his shares. Okay, so a properly structured founders agreement would have allowed him to be essentially dragged along, and if he could not be located and did not respond and did not sell back as required under the contract, provide the company with the right to exercise under a power of attorney in the document, sign his name, sell the stock. Now you take it, you've got to put the money somewhere so you can come and get it and things like that, but that's mechanical. You can deal with that. You could still sell the company. Additionally, this starts becoming important, this concept in terms of death of a shareholder, divorce of a shareholder. If 4 of you get together, any of you on the phone get together with 3 of your closest friends and form a company, one of the things you probably don't want is to have one of those people's spouses coming in saying they now control 12% of the company through the divorce. And, you know, I want to see books, I want to do all these things. Not what you agreed to when the 4 of you started. You agreed that it would be the 4 of you. So if you want to think of it in a terrible colloquialism, you're trying to stay at the dance with who you brought. Okay, so that's what the founders' agreements are made to address. Final document you see on the screen that's up in front of you right now is indemnification agreements. The state law in virtually every state provides different things for which shareholders, officers, directors, other employees can be indemnified. Those are almost always permissive in that it says the company may indemnify. And most bylaws will work that way, especially if you think you're going to grow. But if you're going to be the director of the company and you're sued through the company as a result of something the company did, you're probably not feeling that good about, well, the company may. Because you're not the only guy getting sued. There's 3 others. They're okay. Money coming out of their pocket. Indemnification agreements, in essence, take the right in the bylaws, which is a quasi-contractual right to indemnification and may be permissive, and generally turn that into a full-blown contract between the founder or the signatory, whoever that may be. As you grow, it might be people you put on your board to advise. To a full contractual right can be sued on in court as a standalone and almost always makes indemnity mandatory to the fullest extent permitted under the law. So, again, to circle back to our earlier, one size may not fit all. Sometimes these are very important, sometimes they're not. Something that you've got to think through and make sure you have, especially when you start considering having third parties on your board. Let's get this to move. Okay, corporate formalities. This is another one where 2 things. One, if you're going to actually raise funds, if you remember what we said earlier, the more I see wrong, the more I think is wrong. If the company's been operating for 5 years and there are no minutes of the board of directors, there are no minutes of the shareholders, there's bank accounts, but there's no resolutions adopting the bank account resolutions, appointing who the signatories are, it becomes very difficult to figure out how the corporation is being appropriately run. Okay? Additionally, and everybody hears, and this is one of the questions I get a lot, well, what about piercing the corporate veil? Setting aside that it is quite difficult to do, one of the key things that courts look at is, did you treat the company like a company? Did you do the formalities that companies do? So if you formed it by filing your articles, you opened a bank account, and that's all you did, and you kept running for 5 years, you didn't really have a board of directors, or if you did, you haven't paid attention to it since the first year, there have been no meetings of the board, that's not how well-run companies are run, and will be one of the things that a court would consider in deciding, well, if you're not treating it like a company, then we're not going to give it the benefit of allowable under state law of being a company. The go with faith piercing. So you see that two very important ramifications. We talked a minute ago about the board of directors. Okay, sorry, I'm not sure what just happened. One of the key pieces of the board of directors is to run the company. Most people don't get this, so we'll spend just a moment on this. The board of directors company is set up so that in the capacity as a shareholder, so you're the person who holds shares. And the easiest way to think of this is Ford Motor Company here in town. If you hold shares in Ford Motor Company, what rights do you have with respect to Ford? And the only right you have is to appoint the board of directors by voting on the board. Certain exclusions to that and sale events and some things like that. But generally, the right is to appoint the board. It is then the job of the board of directors to steer and run the company from a strategic sense, as in setting the goals, setting the direction, those things to get where the company should go from point A to point B. And the other thing the board does is appoint the officers and directors, president, secretary, treasurer, VP of tech, whoever those may be. And it is the job of those people, we'll stick with the president, to take the board's direction and turn it into actual operation. Okay, so when you view it through that lens, the board is made to, as you see, provide advice, especially important at the startup stage, to the extent that you can get people who can actually help you think through how to grow your company appropriately, how to utilize various opportunities that come up to you. Sometimes just as simple as how do you deal with getting office space? Do you buy? Do you lease? How do you do those things? That's what you want your board there for. So I've shortened it to be they're meant to advise, get advisors. Starting a board, if you don't have the availability to get them, that's fine. But a lot of times I see where, well, I appointed, my friends, or I appointed my parents, or those things. You really need to think through, do they add value in the analysis of how to grow your enterprise? That's what they're there for. Okay? Officers, we talked about a little bit. President, obviously required in Michigan, also required in Delaware, by the way. Secretary, treasurer. You have to have those in Michigan. No getting around them. And unless you specify certain other duties, the law and general norms will specify kind of what they have and what duties are available to them. Okay? The next thing you're going to get down to is founder contribution. So remember we talked about our founders agreement a minute ago that deals with what are we going to do, how do we get things back. You also need to document the money that came in and to get, and you see now we're back on invention assignments again. You want, and the founders, that even those several companies that I've seen that do a great job on getting invention assignment from their employees often forget that you need one from the founders. So if you recall what we said at the beginning, the invention, the intellectual property rights in the invention go to the person who actually invented it. Okay? But they do not go to the company. So, and I have run into this again, more horror stories where there are no employees. There's 4 founders. They've created software. They're actually out licensing it, and the license is between company A, their company, and other companies. There's a rep and a warranty in that agreement, as there is in all of them, that says that the company owns the software, has the rights to license it, no third party has the right to make claims against it, things like that. If any of you have ever looked at a license agreement, that's what you see. Well, if you think about it from what we just said, the company has no rights into the intellectual property at this point. The individual shareholders, our founders, own it all. So something else to make sure it doesn't fall through the cracks, make sure we can get it cleaned up. And again, go back to let's make sure we've got forms that work in the state we're working in and for the type of person we're using. Then you get to non-competes. So let's go back again. We have our same 4 people. We've got our founders agreement. Often you can build this into it, but if you don't, you want your non-compete. And again, you have the same issues that we've touched upon earlier with the intellectual property assignment. Non-competes are different, and the treatment and acceptability of them are different in every state in the country. So Michigan, where we're at, most of us, I assume, today are at, is pretty okay. It used to be very strongly against non-competes, and that's changed significantly over, call it, the last decade. Non-competes are generally allowable here, subject to some certain provisions. They need to be reasonable in their time. They need to be reasonable in their scope. And by that I mean in scope, if the person is your day-to-day bookkeeper in your enterprise and you're a software company, it will be very difficult, and you only operate in Michigan, having a non-compete that says that your bookkeeper can't compete or have any job in the software industry anywhere in the world, well beyond the permissible scope for most states. Now in Michigan, you may be able to get that what's called blue pencil, which means that if that person challenges it in court, the judge says, well, okay, fine, I'll kind of use a blue pencil strike throughout the world, turn it into the state of Michigan. However, there are states that do not have blue pencil, and if your agreement is overly broad in terms of coverage, scope, or time, we'll just void the document completely. And so consequently, you've gone to all the trouble of getting a document put together, getting a non-compete from all your employees, and your number one code guy who writes your software code for whatever type of code you're writing is now quit, challenges your non-compete, and it's no good. So now he can't compete. He can go compete all he wants. So then we're hoping that the intellectual property assignment is still good because we own the IP now, and that assignment has provisions that he'll make sure we get it, we keep it as the company, and can continue to utilize it. And we'll also have some non-disclosure provisions so he can't use it. So then we're hoping at this point, right, our non-compete just got voided, that while he can go compete, we can at least try and say that anything he does that uses our code, even snippets of it, is violating our intellectual property rights. So you can see why these two are together because they kind of fit together. Okay? Now the one that becomes very challenging for people. It's mine, but I can't sell it. Okay? First off, let's start with the baseline that you cannot, anywhere in the United States of America, under both federal and state law, sell a security unless you have an exemption from registration at both the state and federal level, or you've registered the shares. Okay? Stock in a company is a security. Promissory notes are sometimes securities. LLC interests are almost inevitably securities. Convertible, subordinated debentures that you tried to get around it are almost always securities. If you happen to go out to the angel community, as some of you may have attended the prior seminar saw, the angels often take a promissory note, which may or may not be convertible, which has certain very unusual but sometimes set payback provisions. So people tend to look at it and go, well, it's like my bank. They gave me a promissory note, it's a set amount, also almost assuredly a security. And so just as that stands, you own the stock. Let's assume it's been issued by the company. You own it yourself personally, but you can't sell it because of those laws. Those same things we just talked about apply at the formation stage with the beginning of the company. And this ties directly into this series that Linda's been kind enough to set up, in that the company, when it's formed, and the sale of those securities day one, be it to the four people who formed the company, or someone went out and wants to bring in their sister who's got some extra money. Remember the baseline rule. Unless you have registered the securities, which you clearly haven't, you just formed the company, or you have an exemption from state and federal law, you can't sell them, including to the founders. Now, the founders are easy. I'm not trying to make people upset. It's very easy. There's ready exemptions for those, and you don't really have to be concerned about them for the people that form the company. You should think through them, but it's not an issue. But remember, I raised you wanted to sell some to your sister because she's got an extra $25,000 she'd like to invest, and she thinks your idea is great. Well, now we got a different issue. Now you're taking money from a third party, doesn't matter if she's your sister, and in exchange for which you are giving her stock in a company. That is a sale of a security. In fact, when you talked to her about it and said, well, maybe we could give you 12 shares for $25,000, that's an offer of a sale of securities, both of which are prohibited. Okay? This one I am trying to get you a little bit because I've heard a ton. I've had people go, well, it was friends and family, it was my brother, it was my sister, it was my parents, so we sold it to them. What do I need an exemption for? Well, because remember our baseline rule. Without an exemption or registration, you cannot sell a security. Okay? There are a myriad of exemptions, and the various seminars, both yet to come, including the one in May, which is the all-day in-person, has specific things on Regulation D, which has 3 different components and are all exemptions from federal law, virtually each of which have a corresponding state exemption. Remember I said you have to have both. There's also Regulation A+, which has some corresponding things in most of the states. There's Section 4.2, 4.2.1.5. So there are a number of exemptions available. The key is to make sure that you understand what it is you're either offering, i.e. contemplating to sell and asking someone if they'd like to buy, or actually selling, to whom you're doing those things, how you would like to do them, and finding an exemption at each level that corresponds. Okay? The other thing you see I have is contractual transfer restrictions. That you will often have what's called a shareholder's agreement. Again, we've got our 4 people we've started with earlier. Those are our 4 shareholders. Well, in addition to the founder's agreement with buyback rights, you'd also like to protect the 4 of you against one of you just deciding to sell to somebody you've never met. Someone offers Dan, who holds 25% of the stock. Dan kind of needs money. And someone offers him $50,000 to buy his 25% share. Well, the problem is you brought Dan into the company because Dan not only had the $12,000 that you each put in at the beginning, but Dan was supposed to be the finance guy. Dan was the CPA. Dan knew how to keep the books and talk to the accountant, talk to the banks, and keep that going. The person Dan wants to sell to doesn't know anything about finance. Absolutely nothing. Not a sale you want to have happen. So even if Dan can figure out how to do it under the securities laws, you as the other founders in this company would be rightfully concerned about, well, we don't want this sale to happen. So that's where you have your shareholders agreement. And again, this may or may not be baked into your founders agreement. They often come after because you want each shareholder who signs and joins the company by acquiring an interest or equity stake in the company to sign these. This type of a document is where you deal with the baseline provisions that, okay, any holder of the stock of this company is prohibited from selling the stock of the company unless they meet certain criteria. So the first criteria is often what's called a permitted transfer. That allows the shareholders to sell to certain or transfer to certain entities. So you can often transfer it maybe to your children, or you can transfer it to a trust for the benefit of your children so long as you control the trust. Sometimes you can transfer it to a family limited partnership that you're in control of to help with your estate planning. So there's several permitted transfers that, notwithstanding the baseline rule, no one can sell or transfer, you can do these couple things. Then you're often going to see a provision which, okay, if it's not a permitted transfer, you would still like to sell and you have a buyer, the first thing you have to do is offer it to the company. So the company can say, okay, we, the company, will buy the shares back from you. So you still get, you as the seller get your sale, you get your money, but a third party that's not known to the company doesn't come in, and doesn't come in, and the other shareholders are aware of still of who the owners are. That is often followed up with a secondary right on behalf of the other shareholders. So again, Dan wants to sell his shares. He makes his offer. He gets an offer. He tells the company he has an offer. triggers their right of first refusal. The company says no. Okay, then the remaining shareholders would often have a right of first refusal, so they can step in and buy the shares, and again, another level of potential control of who owns the stock in our small little enterprise. And you can see once we're talking about the beginning things here for startup, why this can be so important. Again, very few people start a small company, even if they plan on making it a huge company, without paying some attention to who the couple of people they're forming that company with are. And this is another level of protection to make sure that you can keep control of that concept and keep the right people that you dealt with in there. Okay, now I think I have about 10 minutes left if I'm right. Looking at the timing right. So if there are any questions, please feel free to let me know. I heard something at the beginning that people are muted, so they don't come through. So Tyler, if you can let me know if there's some questions, if anyone has any that we can address here before we run out of time.
We don't have any questions at the moment, Jeff. We were just sitting here talking, our group that's listening, and it was probably one of the most thorough presentations I've ever heard. So we'll keep track, but at this moment, we do not show any questions.
Okay, well, let me know if something comes through. Happy to answer. For those who are still on the line, it sounds like you get a couple minutes of your lunch time back, so they say you can't make time, but I just did. And thank you for attending. Yes.
Yes, thank you all for joining the third of our 6 Lunch and Learn webinars. We hope you all enjoyed it. We want to thank
I'm sorry, there was a question.
Pardon me?
There is a question, I'm sorry. The question is, do C Corps and S Corps and LLCs have different requirements or obstacles for transferring interests, which allows for the most smooth liquidation of interests as a matter of law? Or does this entirely depend on how the governing formation documents are drafted?
The latter. Subject again, so let's start with the C Corp. Remember, there are certain limitations on who can be a holder. So as far as I think it was the third clause of that sentence was free alienability at law. An S Corp has natural, legal, Internal Revenue Code restrictions on transfer. They don't restrict the ability to transfer other than the fact that you cannot have an improper holder. So that's a restriction on transfer that is imposed at law on an S Corp. Then as far as an S Corp, a C Corp, and an LLC, all of those have whatever restrictions on transfer are agreed to by the shareholders and or the board of directors on an ongoing basis. So you will sometimes see in an LLC pages and pages of the operating agreement has those items we were just talking about with respect to a shareholder script. That has all the limitations. On a C Corp or an S Corp, you would have your shareholders agreement with the agreed restrictions on there. So at law, both the LLC interest and the corporate interest, asterisk again for the S Corp, are freely alienable. They count as personal property, and they can be transferred by the transferor at will. Again, bearing in mind, S Corp has some statutory restrictions, and all of those, C Corp, S Corp, LLC, have the restrictions we talked about in securities law for a moment ago. If it's a security, which you can bet it is in these circumstances, then the transfer of that is subject to federal and state securities laws. And bear in mind, I'm trying pretty hard to use transfer as opposed to sale, because there are a number of cases out there at federal and state levels that if you offer to give someone stock for free, then you have to examine, because the natural assumption in the non-lawyer world is, well, I gave it to them, it's free. I didn't sell anything, I didn't get anything, so it shouldn't be an issue. It depends on, is free really free? And a great example of that is if you're going to give them the shares in exchange for some work they did for you. Okay, well, it's not really free then, right? They did work for you. That work had value. You gave them shares in a company, and now you don't owe them that value, at least in theory. So that I guess just to sum all that up, as to try and correspond to the question, each of them are restricted at a transferability level by general securities laws. The S Corp is further restricted in transferability and alienability by restrictions on the number and type of holders imposed by the Internal Revenue Code. And then all three will, in all likelihood, assuming that the corporation was set up with the thought towards all the things that should be thought through, be subject to contractual restrictions on transfer, which also limit the ability to sell, transfer, dispose of, have a bank come and get, or even a bankruptcy trustee if appropriately worded. Hopefully that answers your question.
Okay, we have two more questions now. They're coming in. The next
Okay.
question is, after the completion of the Articles of Incorporation and the operating agreement for the LLC, what else do you need?
Okay. First off, and we'll this is kind of a technical, Articles of Incorporation are used for a corporation. Articles of Organization in the state of Michigan are what's filed for a limited liability company. One key point there is in Michigan, the default rule if you file articles is that the company is what's called member managed. So each member of the company, as a matter of state law, has full power and authority to make decisions for, run, and represent the company to a third party. If you would like to have the equivalent of what you often see in a corporation, that's called a manager-managed LLC, and there's only one way to do it, and that is to put a line in the Articles of Organization that say the LLC shall be manager-managed. There is no other way to do it. You can't put it in the operating agreement. You can't have an aside agreement. It's invalid. So let's assume we want manager-managed. We filed our articles. We have our line in there that says we're going to be manager-managed. Then you're going to create your operating agreement, or I believe it was called the Limited Liability Company Agreement in the question. Then once that's done, fully signed, and the consideration, the last piece you have to have in the LLC is that the consideration recited to be paid in exchange for the membership interest, right? Nobody gets a membership interest in a company for free. You do something, whether it's you're going to give services, you're going to contribute another property, you're going to contribute $2.50. As long as those things are done, then other than setting up the bank account, you're done. Also important to note that the state of Michigan does not require an operating agreement. So in theory, you could be done, in quotes, simply by filing the Articles of Organization. Caveat to that, for everyone that's on the phone, if you fail to have an operating agreement, then the company will, by default, be governed by the default rules set forth in the code, Michigan Limited Liability Company Act. And a significant portion of the things that you would put into an operating agreement are not dealt with in that act. And consequently, for example, our thing on restrictions on transfer would not be dealt with in a manner that you would normally deal with it in your operating agreement. Okay?
Okay, you ready for the next question?
Yep.
If one of the founders is married, what would be the best way to ensure that the water is not muddled if the partner were to go through a divorce, pre-incorporation?
Pre-incorporation. Okay, so if we assume we're talking about a corporation, you do two things. One, you make sure that the shares upon issuance, and let me put one caveat. I'm assuming this is in Michigan because in some states the things I'm going to say just do not work. California, for example. And this is not bulletproof in the state of Michigan, depending on length of marriage, divorce judge, etc. But it's as good as it gets. You would have the shares, when issued, titled exclusively in the name of the founding shareholder. So this time we'll assume it's Ann. She wants to make sure that her husband doesn't get the shares, and she doesn't have a prenuptial/antenuptial agreement that already deals with this. So the shares are titled in Ann's name. Also, at formation, the shareholder agreement that we spoke about earlier is signed by the founders and has attached to it as a document that has to be signed at the same time, a spousal consent. That spousal consent, while sometimes extremely long and verbose, in essence says, I, Bill, understand that Ann has these shares. that they're subject to restrictions on transfer, that they're also subject to restrictions on transfer to me in a divorce or in the event of Ann's death. And I understand and agree that those restrictions travel with the shares. So in the event, notwithstanding this agreement, a divorce court awards the shares to me, every right that the company had to buy them from Ann, they now have to buy them from me. That spousal consent is incredibly important because of some old dowry right concepts that the state of Michigan still has. All right? Hopefully that's helpful.
Well, thank you. That seems to be all. Again, I'll start with my little spiel here, but thank you so much for participating and for doing this, Jeff. This has definitely been the largest attended webinar that we've had, so thank you for that. Obviously, a very interesting topic to all. I'd like to thank everyone else who joined us. We hope you enjoyed it, and I wanted to remind everybody again one last time that the recorded version will be available on the website probably in about 2 weeks, and our next webinar is scheduled for April 27th, and that topic will be funding your new company. And one last reminder that our next upcoming live seminar will be in Grand Rapids on May 24th if you would like to sign up. The seminar is free and breakfast is, May 17th. May 17th, the seminar is free and breakfast and lunch will be provided. Once again, thank you again, Jeff, and thank you all of you for attending. And have a nice day.
Thank you, Linda, and thank you everyone for the opportunity. Have a good afternoon.